advice do you have to homeowners?
Practicing that preparedness, starting the conversation now is always going to be a benefit to any association out there.
Welcome to Recovery Report Live. I'm Dan Odess, president of GlobalPro, where we manage your risk to recovery, and we have managed more than $1 billion in that recovery. We've also managed more than 1,000 community association businesses, placement of insurance. That's millions of dollars in premium we have helped place to date. So, well, as you all may know, if you've been watching, if you've been tuning in, we are counting down to 10 years. March of 2022 is that milestone. I couldn't be more excited about it. And we have a great guest on today. But before we get there, I want to hit on a few issues, talk about a few things, give you some little updates. As we were expecting, the Florida legislator and the law community are looking for reform in the wake of the tragedy that happened at Champlain South Tower. They're looking at different things. There's a couple things here: waiving of reserves, the making of financing more accessible to associations, increasing liability against developers and municipalities that conduct inspections. That last part is a little bit concerning, particularly for engineers, for experts and consultants. That has been a concern that I've heard from that community from the moment the tower came down. In the days following that is a lot of concern and a lot of emphasis on what does this mean to professionals, more so than the developers and the municipalities themselves. Now, there was a lot of focus in the news and in the press about the developer for that particular building when they built the building many years ago and the variances that were given to them, and then also the role that the local municipality paid in the approvals or the extensions of times, or the emphasis that may have or may not have been placed on the findings by engineers and the inquiries that were sent by the association to the actual municipalities, and some of the gamesmanship that goes on with regards to reserves and waiving them, and some of the emphasis by certain boards or associations and working with their law firms. And what is important? Is the lounge chair really more important than the cracking facade? Well, in the wake of Champlain South Tower, in this tragedy, we all know the answer is absolutely and will certainly be no from a liability standpoint, but just from a practical standpoint, if you're an investor, you're already starting to look at opportunities where, whether you're on the vulture side of it, where you're looking for a dilapidated building or distressed properties that maybe not maintaining things, or on the other side of it, and you're looking for an actual property to live into, raise a family, or to live out the rest of your remainder of your life and to retire there, you're going to be concerned about the reserves and what they're doing and the studies they're doing and what they're doing about the studies that have looked into the infrastructure. All these things are going to weigh on you as you make a determination as to buy or not to buy, which means property values. Property values are going to get impacted. Also, insurance. Insurance companies stepped up. They started wanting to know about 40-year certifications. What's going on with it? What's the status of those things? And were there any delays or extensions given? And you did see some insurance companies threaten to non-renew or to actually cancel policies, or come out and do follow-up inspections or do inspections for the first time ever. Because as we know at GlobalPro, a lot of times when you buy new insurance or you buy a policy for the first time, your insurance company doesn't actually in fact inspect, and then comes along, and then you make a claim and they come along and they say, oh, it's pre-existing, it's wear and tear, but they've never even seen the property. They've never done the proper underwriting, and this post-loss underwriting practice has been tested. We were part of it. We were at the forefront of these issues when dealing with a homeowner insurance company that was treating insureds and punishing them and not paying them when they were alleging that things pre-existing, but they were going back and doing this after the fact, after they've already gotten paid the premium. Certainly not a good practice, certainly not a position you want to find yourself in as a community association or a business owner. On the real estate front, as we are counting down 10 years, March 2022, part of our success has been on the real estate side. We have ventured into real estate here at GlobalPro, so we understand what it's like to own and operate property. And we couldn't be more excited about the real estate projects that are going on in a little area called Alapata, with a multifamily project that's coming up. I'm pretty excited about it because it's right down the street from our own development project. It was announced last year. Unfortunately, because of the pandemic, we're catching up with all of the development and the entitlements and doing these things. We can't wait to break ground on it. And it's great to know that we are positioned in a market that continues to grow, continues to appreciate, and opportunity is abound. I know The property values, if you're a homeowner in South Florida, you've seen them rise. You've seen them rise at historical rates. You've seen opportunity come about, but GlobalPro has been right there, has been part of that growth, has been part of those opportunities, and is working on those projects. That's what makes us uniquely positioned to help you as a business owner, whether you're in commercial real estate, whether you own and operate these properties and these things. We are doing it as well. We're right there alongside you, getting the insurance, planning the projects, mitigating risk and downside, looking at balance sheets, understanding what the market wants or doesn't want, or projecting or predicting it. We're working with our investors, we're working with our teams to make those determinations as well. Speaking of business and business strategy, we always want to talk about it because this is about giving you information you can use. And I just saw an article actually this morning, and I added this little piece here near my intro about the 4 skills that make the best managers. I love this: adaptability, curiosity, detail-oriented, tolerance of ambiguity. I love it. It's on the CNBC. Go check it out. We'll have the link. We'll make sure we include it in the email blast. I really think if you're in anywhere position whether you're an entrepreneur or you're sitting at the top of a corporation trying to make decisions, trying to figure out how to hire, particularly in this market, how difficult it is to find good talent that is reasonable, that understands what it's like to be part of a team, especially at GlobalPro, you're gonna want to read this article. I love it. I think there's 4 points, there's 4 skills that make the best managers. And it really spoke to me, and that's why I included in this segment: adaptability, curiosity, detail-oriented, and tolerance of ambiguity. Particularly the one I like is the curiosity one: approaching problems in novel ways, seeing patterns, understanding how to synthesize complex information, having the desire to achieve a deep understanding of things. I love it, and I really think that works particularly in insurance. If you're a business owner and you don't have curiosity about insurance or basic business practices, there's no doubt that in our world that changes so fast with technology and all these things, you're more than likely going to fail. I mean, the fact of the matter is that if you are not curious in nature, or someone on your team in some upper level management position does not have curiosity, particularly today, I think it is absolutely a recipe for failure. Now, you marry that with adaptability and being detail-oriented and a tolerance for ambiguity, and I think you definitely do shape the rights or create the proper construct for the best manager. And this best manager for your community association managers out there, I really think this actually applies to you too. Things are changing. You have to be able to adapt. You have to have curiosity. Systems are changing. Technology is changing. You're seeing robotic garages. You're seeing, keyless entry to stuff. You're collecting data and information. You know how to protect those things. You need to be detail-oriented because you have so many different systems and so many people you have to rely on to do those things. And you have to have a tolerance for ambiguity. Why? Because your unit owners and your board members, they all have different experiences, come from different parts of the world, and they all can share those experiences, and those experiences may shape a decision or the direction in which your association is going. So it's really important to be your best manager. So when you see these things from CNBC or Business Insider talking about managers, take the time, read these things, because I think it may even be able to help you hone your skills. So great stuff. Well, let's talk about a pioneer. Our next guest is that. It's certainly a transplant from California. We have many of those now in South Florida. Maybe he was a trendsetter in his day by making the voyage from California to the South Florida market. But him and his firm have had a tremendous amount of success. But without further ado, I do want to bring on our next guest. Hey, Paul, welcome to the show.
Thank you, Daniel. I appreciate the opportunity.
So, Paul, I appreciate you taking the time to be with us. Paul Terry, he's with Angius and Terry, the law firm, which has specialized in resolving construction defect issues for community associations for over 35 years, with over $750 million in recovery for those defects. A tremendous amount of success, certainly, and a wealth of knowledge and information. I'm really excited to have you on. Through the years, Angius and Terry has had a single mission, and I like this, and that's why I'm adding it. That's why I want to add it. I want to mention it: to provide our clients with exceptional service and superior legal representation. There's a lot to unpack there, but I love your mission statement. That's why I just had actually yesterday met with my team, my managers, and we were talking about our mission statement. I really like yours: to provide our clients with exceptional service. I love adjectives because they can mean so many different things, and there's an emphasis there on service and then the legal representation. So I love the order in which you put them. I think you guys are doing a great job. But tell me a little bit about the firm. Tell me about your clients. Tell me about the focus.
All right. Well, our firm has a limited practice. We only represent community associations that are experiencing some kind of construction issue. Our clients are primarily condominiums and townhouses. We don't do single-family homes. We don't do hurricane claims or other first-party type claims. It's just limited to construction defects. And I should mention too, a lot of times you'll hear people refer to the 558 claims, and how does that relate to construction defects? And they're the same thing. There's just different ways of describing it. The construction defect statute in Florida is in Chapter 558, so people call it a 558 claim.
Yeah, I think it's something I spent some time going. Someone just come up with this name, this number, or an acronym. This is literally actually a Florida statute. It's been ripped out of there and then associated with the idea of claim, and then people get confused between the different parts of it. So definitely a good point. So so how did you get started there? I mentioned as I was giving your introduction about your voyage from California to Florida, but what brought you here? How did you get started, and why construction?
Well, I started out of law school working for a business and business litigation firm in downtown San Francisco. And it turned out that one of their clients was a savings and loan. This was in the early 80s. A lot of the savings and loans in those days, trying to increase their profits, did joint ventures with developers and building all these condominium projects. And when they went south, of course, everybody went after the bank because that's where the money is. And so I spent my first 5 years of my career defending developers, primarily that bank. But then I got tired of being, frankly, trying to take advantage of homeowners and trying to reduce the claims. And so I hooked up with Mr. Angus, and we started our firm and representing community association clients and trying to make sure that they got sufficient recovery that they could actually get their homes fixed.
No, awesome. So today's topic is construction defect claims, the do's and the don'ts. So I want to get through a few of these things because obviously a very hot topic. You know, in the wake of any major disaster like the tragedy of Champlain South Towers, you know, these trends start to occur, and I definitely think one of those trends now is a hyper focus on the actual turnover and new construction and the possible changes in standards and practices as these buildings age, and recertification, how it was only mandated really in Miami, but now Palm Beach and Broward and other parts of the state, possibly even a statewide mandate to institute some sort of thing. And even, you know, I heard on a panel just recently that even nationally, the federal government's looking at some sort of standard and practices that may be required for aging infrastructure, not just federally managed stuff, but also privately held or association type property. So let's start. So the first question I want to ask you is what are some of the biggest construction challenges facing developers turning over new buildings to an association? Now, again, we understand you represent most of the associations against the developers, but sometimes there's a lot to learn from that, and there may be things that developers can do to just help the process so you can help your client maybe expedite the process in resolving it. So we want to be solution-minded. That's why I want to start off asking a question about, okay, what can we possibly say to these developers to try to mitigate some of the nonsense, some of the bullshit stuff that we see that kind of clogs up the process? We had mentioned, we talked a little earlier before you came on about some of these things. So I'm interested to hear your take on this.
All right. So I think the first thing for me to emphasize is that what we're after is the best results for our clients. And sometimes that involves us handling a huge case and frankly making a lot of money. And sometimes it involves making the right moves right at the very beginning and coming up with a quick, effective solution for the client. That's what's ultimately in their best interest. And that's what we're always after. There's enough problems that we'll do okay if we're looking out for the best interests of our clients. And I think the biggest thing that developers do wrong as part of the transition process, and I'm focusing really here on the developer, and that is that they take an antagonistic view towards any problem that might exist with the building, number one. And number two, they allow the general contractor and the subcontractors to handle exclusively the warranty process. What I think the developers need to do, and I think it's in their best interest as well as the associations, is to recognize that this is their product. They're actually on the same side as the association, and if the general contractor, the subcontractors did something wrong, then they should be as interested as the association in making sure it's taken care of properly. And there's all kinds of benefits that come from that. Number one, if there is a problem, the general contractor and the subs are still around. They're still in business. You can make sure that they take care of the problem. Number one. Number two, if there's damage that's occurring because of a construction problem, the damage hasn't gotten that bad yet, and so the cost of fixing that problem or fixing what we call the resulting damage is much more reduced. And again, if it does get into litigation because you can't get it resolved, then all the subcontractors in the general all have their insurance in place. And there may be multiple years of insurance, and all that's available not only to the association, but really to the developer and making sure that it gets taken care of. So one of the biggest sources of our business is developers, or really more general contractors, telling associations, "Oh, you're past your 1-year warranty," and that reflects the fact that they may have given a 1-year written warranty, but the law implies a 10-year warranty. So telling somebody that they're past their 1-year warranty is just saying, "Hey, listen, I'm not going to take care of your problem. Go talk to a lawyer, and then we'll figure it out then." And that's just counterproductive. It's in nobody's best interest.
So switching gears to the board side of things, right? The association of this building has been turned over. They want to engage counsel. They want to have representation, right? Because as you said, right now, I've seen this myself, it's very antagonistic, right? You're very defensive over it. And again, approaching these things logically, and accepting the fact that maybe it wasn't perfect, and being open-minded about that. But from a board's perspective, they do want representation, right? Because they're going to be afraid, it's a bunch of volunteers. They're not getting paid to do this. They do have exposure and liability. We all are aware of this, particularly with the spotlight that's put on it in the wake of the tragedy that occurred in Surfside. All right, so when they're retaining a law firm to represent them under the Florida Statute 558 in a lawsuit, what should they expect? What's the cost that's typically associated with it? How long will it take? What kinds of questions should they be asking? Kind of give us an overview of what you think, being in the business 35 years, obviously, if not longer, and what can some of these board members, do better?
Well, I think there's a couple of things. Number one, when you're evaluating whether or not to bring a 558 claim, because and let me just say, there may be construction defects, but there are serious defects and there are minor defects, and minor defects shouldn't be leading to a 558 claim. That's just not cost effective. It's not in anybody's best interest. And so you want to start talking to a firm that their primary business, or at least a significant portion of their business, is handling 558 claims, because that gives them the breadth of experience. The second thing, I think, is that you want to have a firm that is at least willing and capable of handling a case on a contingency fee basis. Now, there are some cases, some circumstances where you might want to hire an attorney on an hourly fee basis. Those are fairly limited, but there are circumstances. But one of the real advantages of talking to a firm that is willing to take your case on a contingency fee basis is that they're forming an independent judgment as to whether or not your case makes any sense. If you hire an attorney straight hourly, they're going to get paid no matter what. And therefore, they're not going to have the same sensitivity that you have with a firm that's handling a lot of cases on a contingency. And so even cases where you may want to hire somebody on an hourly fee basis, and those are typically going to be your high rises where there's a large amount of money involved and you can afford to do it properly. I still think you should be asking them, listen, will you take our case on a contingency? And if they hem and haw about it, well, then you don't want to be hiring that firm, because either they're unable to handle it that way, or they're not really certain as to whether or not you have a good claim. And we've seen lots of cases where associations have come to us. They have a multi-million-dollar judgment against a defunct entity, and they said, well, what can we do about this judgment? It's like, well, nothing now. I mean, maybe you could have done something about it before, but those are all, considerations that you want to be making at the very outset before you start committing a lot of resources.
I think it's great advice, and we do most of our recovery work at GlobalPro when retained to do that on a contingency fee basis. So I can completely relate and understand that, and it's difficult sometimes when you have these so-called experts and consultants come out with these fee-based contracts and try to talk about how our interests may be in inflating things and doing those things. It's like, well, wait, we're in business to make money. If I inflate things, it's more than likely, almost always, going to take much longer than it needs to, and I may not even get a better result. I may get a worse off result because I'm now clouded the issues that actually could have been paid. So it's just, you got to be reasonable at these things, and you got to have an understanding and a measure of what it means to be successful. And I think success is not just getting the most amount of money. The success is also meeting or exceeding the expectations of the client, and that expectation of the client may be to getting paid tomorrow, not 10 years from now. And I think a lot of people forget that if I'm working on contingency base, that means I'm not getting any money for 10 years. Why would I ever want to be in a situation that is that? It just doesn't make any sense. It's just diminishing returns, right? So
yeah,
absolutely. Yeah, I think that's a really important and definitely some sound advice there, and definitely certainly a question. Now, that's not to say that any sort of hourly or hybrid situation isn't the right fit for some. Right. So, like, again, I think you were balanced in that, in that perspective on this stuff. But I definitely understand again, it demonstrates confidence. It demonstrates a partnership, really, like with your client and trying to get this done and get it done in a reasonable amount of time for the right amount of money. That's really what it's about. And I think you'll kind of set aside a lot of that other stuff, which leads into a lot of disputes and everything else. And there are some particular law firms out there very well known for generating some hefty bills. So, and I'm sure you know them and I know them as well, and they'll remain nameless. But what is one of the most common mistakes a board typically makes at the beginning, middle, and end of a 5-5 law? And I like to emphasize the end, right? But there's some things they do real quick right off in the beginning. I'm sure there's a lot of things we can talk about in the middle, but the beginning and the end, let's emphasize that. Let's focus on that real quick. So in the beginning, what are mistakes are they making in the beginning, and then we can talk about the end.
All right. So I think that the two biggest mistakes, three maybe, that I see at the beginning of a case is number one, and this is slightly self-serving, so I'll own it, and that's that they allow their community association attorney to handle the preliminary dealings of the claim. There's a lot of great community association attorneys out there, but if your bread and butter is not handling the claim, it's easy to make mistakes. It's easy to take positions that end up putting you at a disadvantage, down the road. And again, you don't have that focus. You're kind of just going through the process. And so you really want to be talking to somebody that does a lot of handling these 558 claims. I mean, that's probably the biggest issue. Another thing to be aware of, it's not necessarily bad, but it's out there, is that a lot of community association attorneys have a referral arrangement with a 558 attorney. There's nothing inherently wrong with that. It's permitted by the rules of professional conduct. But if your community association attorney is trying to talk you into hiring a particular 558 attorney, as opposed to presenting a several of them, then the board should be asking the question, okay, why is this person being referred? Maybe we should talk to a few other firms as well, not necessarily to ignore the advice of our community association attorney, but to make sure that we're making the best decision for our association. I pay referral fees. I get brought in by a community association attorney. I'm not saying there's anything wrong with it at all, but a board should be asking a few questions when that situation arises. Why are we talking to this particular 558 firm?
And when it comes to the end, and we're headed, maybe we're headed to the settlement table, or we've settled. What are some of the mistakes you see with boards at that point?
Well, there's a couple of different things that you actually alluded to one of them a little earlier, and that's that a board that has an unrealistic expectation as to what their recovery is going to be, and insists upon taking a particularly aggressive position, is going to end up not settling their claim as quickly. They're probably not going to recover more money. Just because you take an aggressive position doesn't mean your claim is worth more. And they try to substitute their own general business judgment for the judgment of the 558 attorney who's doing this every day, and says, no, your claim isn't worth that much. Don't do that. You need to settle in this range, and they just don't want to listen, and that just puts it off and puts it off. It's hard. There's a lot of board members who are very successful attorneys. Business people. They may be successful real estate investors, but that doesn't necessarily mean they have the expertise for how to handle one of these construction defect claims. So I think that's probably the biggest problem. The second thing, and I think this is really important, is that before you ever settle a claim, you should be talking to contractors about what it is that you can get done with the net recovery that you're going to have. We think that's pretty crucial to your fiduciary duty, so that when you sign on the dotted line on a settlement agreement and that's the end of your claim, you already have a pretty good idea of what it is that you can get done. You don't want to be committed to any particular contractor, but you certainly want to be consulting with one so that you're making an informed decision as to whether this is actually the right amount for you to be settling in your case.
Makes sense. I mean, all sound advice. That last part there is, I'm glad you emphasized how important it is, because that's definitely, they look to you, right? They're looking to you, they're looking to me on, what should I take it? Should I not? And it's kind of like, look, man, I'm not going to be doing the work. So, it's, it really depends on what work you're going to do, what scope it's going to be. And then, obviously, what life safety issues you have to address. There may be various different things that need to take precedent over some of the other, maybe cosmetic things that you may have been, litigating or disputing with the developer, right? So, order of importance and value and costs associated with it. And some of these, 558 lawsuits take time, right? So you might have started it in 2018 and now you're here in 2021, right? And you're at the settlement table, and shockingly, labors are scarce, material is scarce, prices are skyrocketing, there's shortages all over the place. So, you got to take all those things into account, right? As to, what is going to go. So where you started may be very different to where you end. And it may go the other way too, which is you may start it out in 2021 with the lawsuit, and now we end up in 2023 or 2025, and things are cheaper, and labor's in abundance, and materials are in abundance, and prices are less. So, your claim's going to change, things are going to evolve, and it's definitely really important. You emphasized again the expectation. We talked about that a little bit before we came on today, about properly setting expectations. And I mean, that's just a basic general business practice that a lot of us should. But the expectation you talked about was the expectation of the board, their expectation, which may have nothing to do with what you are doing or what we may be doing, or and anything to do with the actual facts in their own case. They just want blood, and they believe at any cost we should get it, right? So, but the reality is that they have fiduciary obligations, which you mentioned and emphasized, which I think was just so on point, and I definitely think was really sound advice. I've hinted at it, I've talked about it, we've mentioned it a few times at various different parts of our conversation here in my earlier segment, the Champlain South Tower. I certainly don't want to digress into a whole conversation about causation and issues and liabilities, but one of the things I mentioned earlier on is that they put this task force together to change community associations and their guidelines and things like that. One of the things that I didn't see mentioned in that task force was actually the impacts they may have on the 558 process and construction defect claims. Do you believe there's going to be revisions to the 558 process in that statute as to association bringing claims against developers?
I do think there's going to be something there, although obviously there's going to be a battle in the legislature It's really interesting. The head of the task force is essentially a defense attorney, um, Carlton Fields,
That's right.
and one of the recommendations of the task force is that any restrictions on bringing lawsuits against developers within the scope of the statute of limitations be eliminated as void against public policy. Um, the thing is that all these restrictions are put in, particularly into governing documents, CC&Rs, declarations, that sort of thing. But those really aren't agreements. That's an agreement between the developer and the developer, and because the developer is controlling the board at the time. And eliminating that, I think, is going to be one of the big changes that takes place. The other one that I think is important too is that in any kind of condominium, there's required to be engineering turnover report, and there's 13 items that they're supposed to look at. And there's two important changes I think we're going to see. One is that they're going to add waterproofing to the list, because waterproofing is probably the single greatest cause of major construction defects. So that's going to be added in. I haven't seen it mentioned yet, but hopefully through the legislative process, we're going to be able to include some requirement by the engineer who's doing the report as to the actual condition of those various components that are required to be covered. Right now, what we're seeing is that there's very generic responses. You know, here's how you maintain something, and it's not specific to that particular project. There's no evaluation as to how it was built, whether it was built correctly, and so these engineering turnover reports today are largely useless. And so hopefully that gets changed as well. And then finally the requirement that there be some accountability with respect to reserves. Because one of the problems that we run into is boards say, listen, you know what, I'm only going to be here for 3 or 4 years. We've already waived our reserves. I don't want to spend any money. I'm going to keep the assessments as low as possible. And that's just not realistic for the building itself. The building's going to be there. It's going to need repairs. It's going to need reserves, and we have to be much more realistic. And unfortunately, we probably have to impose some requirements on those early boards to make sure that they are properly setting aside money to take care of problems which may not come to light for 4, 5, 6, 7 years down the road.
Well, Paul, man, this has been awesome. We definitely went a little longer than we typically do with this, but I just enjoyed the conversation. I think there's so many, just great advice. There's so much great advice in everything that you're saying, and I think this is a fantastic opportunity to talk about these important issues, talk about them differently. I mean, your practice area is really hyper-focused in the construction defects. You definitely have a wealth of knowledge and information and experience. Certainly shows. It's been an absolute joy to have you on here to talk about these things, to get into the weeds and details of some of these things, and to give people kind of like that checkbox, right? Don't do this, do this. I definitely think we have that here, right? You said first, second, third. I mean, you were able using those words, and I think, for those that are listening to this live or watching it, and those that may watch this later on as a recorded piece, hone in on that, take the notes, and follow those guidelines. I think there's some really solid advice there. But I really enjoyed speaking with you today. How can our audience find out more about your firm?
Well, I'm going to do something that you won't see an attorney do very often, and that is that my cell phone number is 702-450-2900. And that actually will ring on my cell phone, and I will take your call. I'm happy to talk to people. I do it all the time. They can also go to our website, www.constructiondefectlaw.com. And one of the things that we have on that website is a frequently asked question tab that actually links to our YouTube channel. And I go through it and answer maybe 80 or 90 different questions. They're very short. They're usually 60 seconds or less. And so you can do a search on any question that you might have. And we'll have a little video explanation of what something means or how you go about doing something.
It's awesome. Great resource. Go check it out. And while you're there, hit the subscribe button, hit ours as well. Again, Paul, thanks so much for coming on today. Again, it's been a joy to have you on. That's Paul with Angius and Terry, tons of experience, a lot of great information, and we will certainly make sure that this is distributed, and it will be on our YouTube page. We'll make sure that we're sharing it, obviously, with your entire team, and hopefully they can share it with your clients. And there's a wealth of information. Things are changing, and this is the best way to keep up with those things. So again, Paul, thanks so much for joining us today.
Well, Daniel, listen, I want to thank you for having me. This is a great program that you have, and anything that we can do to help educate our clients is certainly in their best interest, and I think ultimately in ours as well. And I just want to say thank you very much, and what a great program.
I appreciate that. Well, that was awesome. It was awesome to have on guests that have the knowledge, the experience, the expertise. They hone their skills. They know what they're talking about. You can see right there, 35 plus years of litigating, spending most of the time dealing with construction defect issues. It's awesome to talk about these issues. It's such an important issue, particularly in South Florida, but I really think that throughout the country, with the speed at which things are changing, the explosion of developments, the evolving markets, this firm has offices throughout the country in major metropolitan areas that are seeing this tremendous growth. So do we at GlobalPro, and we are continuing to expand. I'm so excited. I can't wait. Next week, we'll be in Dallas all week. I'll be broadcasting the Recovery Report live in Dallas. We'll be doing a live broadcast with Rob Bowlby, our market president, that will be giving us some information about insurance and local market issues that he's dealing with, that he's learning about right now in Dallas, in Texas, that are impacting and changing things there as well. So I hope you all join us, but never forget, hit the subscribe button, like us and follow us on all our social media. We want to make sure that you have the information you can use, and the best way to do that is to stay here, stay with us every Thursday, 11 o'clock. Tune in, listen to the entire broadcast, get the information you can use, whether you're a community association board member, manager, or a business owner. This is your one place for that. And our YouTube channel has lots of videos, testimonials, videos like this, the Recovery Report Live. It has do's and don'ts. It has all of this information right there at your fingertips. So there's no excuse why you don't have the information you need as a board member, as a manager, as a business owner. If it's not there, you don't think it's there, or you want further explanation, hit us up, 855-487-7475, or recover@getglobalpro.com. There's so many different ways to connect with us and our amazing team here as we count down to 10 years, March 2022. Continue to follow us, continue along, go through the journey with us, what makes us successful, what were our stumbling blocks, and maybe there's something you can learn from it. Maybe there's something you can learn that can help your business or your association operate at a higher level. Again, thanks, Paul. Thank you so much to his entire team for joining us today. Thank you to our audience for being with me here today. We'll see you next week on the Recovery Report Live.